Welcome to those of you that have joined. We have just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to the Five Stone Buildings webinar program. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for everybody to join, I shall just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of your screens, and our speaker will try to come to the questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker does not identify you in your response. And just to remind you that we now have a separate section on the Five Stone Buildings website for webinars, where you'll be able to find a copy of this recording and the slides used, and copies of any previous webinars that have taken place. I will now hand over to Beddoe.
Well, hello everybody, and thank you so much for joining us on a Friday in August. What is the chance of that in normal circumstances? And I do hope that it means that some of you will be able to have a summer holiday at some point. So the topic for discussion today is whether trustees can take their costs from the fund in removal proceedings. And the reason that Rose and I wanted to look at this was because it has cropped up in a case that we have been involved with recently. And we were somewhat surprised to find that, notwithstanding looking at cases decided all over the world, there isn't really one single case which makes the point very clearly and drives the point home. So can we have the next slide, please, Jo? The circumstances that we find ourselves in this scenario is that some disgruntled beneficiaries have brought a removal claim against a trustee. And that, of course, can take a number of forms. It can be based on breach of trust allegations, or it can be based on the fact that the beneficiaries have lost trust and confidence in the trustee, or that the relationship has broken down to such an extent that administration of the trust proves impossible. The trustee, faced with this claim, wants to know whether it can use trust funds to defend the claim, relying on the right of indemnity, which it has, either in the trust deed or in other sources, which Rose is going to deal with next. So what is the correct advice to give to the trustees in those circumstances? Jo, if we can have the next slide, please. So, Rose, what right of indemnity does a trustee have as a matter of law in respect of their costs and liabilities?
Thank you, Penny. So the indemnity that the trustee has, I don't really want to just read off the screen, but it's set out there. And in essence, what it is a right to look to the trust property to recoup costs and expenses and other liabilities that they've incurred in the course of their role as trustee. And you can see why that's necessary to ensure that a trust functions properly. And as is set out on the screen, that can be by way of an express clause in the trust deed. And that's something we're going to discuss a bit later, about whether you can have an express clause in a trust deed that expands the right of indemnity under the general law. And then you also have, of course, the statutory provisions. So that's section 31 under our own provisions. And then in Guernsey and Jersey, you have similar provision there too under their trust laws. And this is a tightrope that is often quite difficult for trustees to tread, as to when costs and expenses will be incurred in the course of their role as trustee. And obviously we see quite a lot of arguments about that. And in particular, this is a difficult question when you have litigation against the trustee. So, I mean, in England, we have Practice Direction 46, para 1.1, that provides that a trustee is entitled to an indemnity for costs that are properly incurred in the course of litigation. But of course, that doesn't really give any particularly helpful guide as to when that will be, or in what circumstances. So, Joe, could we have the next slide, please? So, Penny, how does the trustee's right of indemnity interact with litigation?
Well, I think that the starting point is always going to be the decision of Mr. Justice Lightman in Alsop, Wilkinson and Neary, which is a very useful case, not just on this point, but also because it dealt with the difference between a Beddoe application and a prospective costs application, and also the need for Beddoe proceedings to be in separate proceedings. And indeed, I think it's right to say that the leading counsel who appeared in that case, who later became a High Court judge, got rather a dressing down for the approach that had been taken. But the reason why Alsop, Wilkinson and Neary is important is that it concentrates on trustees' costs. Quite often you find, even in the cases, that the focus is on the case of Re Buckton, decided many years, nearly 90 years previously. But Buckton is about beneficiaries' costs, and it's really quite important to make that distinction. So Alsop, Wilkinson and Neary talks about different types of dispute. It talks about trust disputes, which can be anything, for example, whether the trust was validly constituted, or it may be a construction point or something of that kind. And then you have a category 2 dispute, which is a beneficiaries dispute. And that essentially is the sort of hostile litigation that beneficiaries can bring against trustees, whether that's a breach of trust claim or whether it is a removal claim, the subject of what we're discussing here. Mr. Justice Lightman makes it very clear that a removal claim falls within category 2. And then finally, there is a sort of third party dispute that a trustee may find themselves embroiled in. So, for example, the trustee may hold a lease on behalf of the trust fund, and the landlord might be suing the trustees for breach of that lease. To take that example, or the trustees may have incurred liabilities for which they're being sued by a third party. And it's in that sort of third party dispute that Beddoe relief may become important. That was really why Mr. Justice Lightman was analysing matters in this way, to point out that it was really only in the third type of dispute, the third party dispute, that Beddoe relief was available. Joe, can we have the next slide, please? So, Rose, what are the costs rules in category 2 disputes?
Well, the cost rules in category 2 dispute can be quite simply stated on a general level, which is that they follow the event, just like normal litigation. So generally, I mean, you can't say for sure, but the general rule is that the loser pays the cost. and that includes determination of the trustee's right of indemnity, because you won't know until the end of the proceedings whether the trustee has acted reasonably in defending them. Because of course you need to know A, whether they've lost, but B, even if they haven't lost, were they acting reasonably in how they acted in the proceedings. So that is really something that has to come right at the end when you've got the cost determinations. And there was a recent Court of Appeal decision, Price and Saundry, where Lady Justice Asplin set out in quite a lot of detail how you do determine the trustee's right of indemnity when you come to that at the end of proceedings. And she set it out in two quite neat questions, which are on the slides, which is, one, were the expenses, were the costs properly incurred? And two, were they incurred by the trustee on behalf of the trust? Which is obviously a very relevant consideration when you've got removal proceedings, the defence of which is generally going to be pretty self-interested. And there's this interesting interplay, because if a trustee successfully defends a breach of trust or a removal application, generally they will get their costs out of the fund, even though you can see why that defence might be construed as self-interested. But on the other hand, if they unsuccessfully defend a removal or a breach of trust, then generally they won't get their costs, although not always, because they won't have been incurring those costs as trustee on behalf of the trust. So Joe, could we have the next slide, please? So what does this mean for the trustee in a removal claim?
So as Rose has already pointed out, the trustee may well get his or its costs out of the fund at the end of the claim, particularly if it's been successful, particularly if the trustee has taken as neutral a stance as it can, and we'll come on to how the trustee might do that in a moment. But it does seem pretty clear from such authority as there is that it cannot take its costs out of the fund as it goes along. And I recall being involved in a removal case, Alkin and Raymond, which unfortunately is not reported on this particular point, where that's exactly what the trustees had done, and they were forced to repay the funds that they had taken out of the trust as the removal claim went along, with a fairly swingeing rate of interest. As I said, it's unfortunate that it's not reported on this particular point. The case has become known as the lingerie case, because one of the removal grounds was that the trustees had been buying one of their major beneficiaries' underwear as a present, but we didn't succeed on that particular point. But
she'd rather acquiesced in the lingerie buying.
Yes, that's exactly what the judge found, that she had acquiesced in the lingerie buying. But Rose, to take a couple of more serious examples, what about the Skafturas and Demos case?
Yeah, so this is one of the cases that we came across on our round the world tour of authorities relevant to this issue. And this is an Australian case which featured a very naughty personal representative who had in fact been paying himself out of the estate as the removal proceedings went along, and he'd been doing that but also failing to pay what he should have been paying, so it was kind of a double sin. And the judge at the end of the trial said, well, it was totally improper for him to take his costs from the funds of the estate before the proceeding was concluded, and any appropriate order as to costs made in his favour. He did actually appeal on various points, and one of the points on which he appealed was that he said that the trial judge was not entitled to take into account the fact that he had been doing this, that he had effectively been raiding the trust fund as he went along. He said that, well, the judge couldn't take that into account because I had an indemnity, and he referred to a case called National Trustees, Executors and Agency Company of Australasia Limited against Barnes. He said, well, that means that I wasn't doing anything wrong. He said, well, in Barnes, the High Court said, well, trustees can be indemnified out of the fund for all proper costs, charges and expenses. In Barnes, the trustees, having successfully defended a removal application, were entitled to their costs. Once it had come to the end of the proceedings, once they successfully defended it, the court said, okay, fine, you can have your costs. And it's fair to say that the Court of Appeal had absolutely no patience for that analysis whatsoever. And they said, well, of course, Barnes isn't authority for the proposition that this PR was entitled to take his costs when his resistance to removal was unjustified. And they said, well, the right to the indemnity depends on the conclusion that the costs were properly incurred, and you won't know that until you get to the end of the proceedings. So I think, while trustees may say, okay, well, at the end, I will have my costs, you just won't know that until you get there, effectively. So what about Sherburn, which is a nice recent one, which was handed down by the Guernsey Royal Court, I think a couple of months ago?
Yes, and this is a decision of the bailiff. And again, it's not directly on point, but it's extremely useful in this context in that it goes through some of the general principles that underpin this particular area of law. In Sherborne, there was a claim against former trustees and who had been removed. And they had incorporated into the trustee, by way of variation, an indemnity that did allow them to take their costs of hostile proceedings out of the fund. And it was interesting because, the bailiff was clearly highly unimpressed by that variation to the trustee. But first of all, the bailiff considered that might well be contrary to public policy, in that trustees shouldn't be able to fund proceedings that are being brought against them out of the funds that they hold. And that really, that particular point really underpinned the whole decision, which really related to the validity of the variation, but also the construction of that particular clause that had been inserted into the trust deed. And that is certainly very, very helpful, and something that sets out the principles very, very clearly. And in particular, the quote that we've put on the slide, that the trustee must reach its own decisions as to whether to take advice or be represented, in the knowledge that those expenses might not be recouped by it. So a real warning shot across the bows to trustees facing removal proceedings. Jo, can we have the next slide, please? But what happens if there's no breach of trust allegation? What happens if really this falls into that category of removal applications that in fact deal with allegations of loss of trust and confidence in the trustee, or just really relate to the fact that the beneficiaries and the trustees are at loggerheads? Rose, what difference does that make?
Well, I think it makes no difference, because the core question is whether the trustee has acted reasonably in defending the claim, sort of the flip side of whether the costs are properly incurred. And they can unreasonably defend a claim and lose, even if that claim contains no breach of trust allegations. And I think that's particularly relevant in an English setting, because with recent authorities like Schumacher and Clark, the court is quite clear that it's not really going to be that interested in making findings of misconduct effectively, and in fact it usually won't. So I think it wouldn't be a principled basis to say, well, just because there's been no breach of trust allegation and no finding of breach of trust, that means the trustee should have its costs, and B, that can't be classified as kind of the hostile proceedings, your category 2 disputes. So in essence, no, I don't think it depends on a breach of trust allegation. What about those cases, Penny?
Yes, I mean, there are salutary cases where, in fact, trustees have been removed, where no wrongdoing has been found on their part, but they have still ended up with a costs order against them at the end of the day. And we've mentioned Griffin and Higgs in there, and also Perry and Neupert, which was a case that I was involved in when it got to the costs element of the claim, and a case I feel rather aggrieved about even still. That was a case where Dr. Neupert had been appointed as an executor of an estate, which was left to the deceased's wife, but there were a number of creditors who claimed against the estate. And the wife and her daughter disputed the standing of the creditors to pursue their debts. And what Dr. Neupert did in the face of a removal application by mother and daughter was at a very early stage to say he would step down, but he was very opposed to the proposal that the mother and daughter take over the administration of the estate, because they had made it clear that they disputed that the creditors had any standing, and he wanted somebody independent to look into it. And he stayed on while a dispute raged, ultimately between the mother-daughter and one of the creditors, as to the identity of the new executor. And it seemed to me that, bearing in mind that Dr. Neupert had offered to go at such an early stage, but was concerned that he went in favour of somebody who was independent, it was extremely unfair that at the end of the day, a costs order was made against him. And this was on the basis that, in the end, the judge who heard the removal application did appoint the daughter as an administrator, but together with an independent administrator as a check. Something which I suspect Dr. Neupert, had he been involved at that stage, would have been more than happy about. I think the decision was a wrong one. It seems to me that Dr. Neupert had done what he could do in those circumstances. But it's a salutary tale that even in cases of no breach of trust allegation being made, the trustee has to think very long and hard before deciding whether or not to step down. Can we have the next slide, please, Jo? So we've talked earlier about the sort of indemnity clauses, often very wide, that one finds certainly in modern trust deeds, and very much so in offshore modern trust deeds. But Rose, if there's a really broad express indemnity, broader than one might normally find, is that going to help the trustee?
No, I don't think so, or at least it shouldn't. So what we're typically talking about is a clause which says that the trustees are not liable for pretty much anything that is not due to the trustee's own willful neglect, default, gross negligence, if you're looking at an offshore trust deed, fraud, etc., etc., and that the trustees are entitled to be indemnified out of the fund. And well, so the argument goes, well, doesn't that mean that if they're not going to be liable for anything, save, say, fraud, doesn't that mean that the trustee will always have its costs of the removal application, irrespective of the result, really, whether it wins or loses, unless allegations against it are made out, which fall within the very limited categories of extreme behaviour set out in the indemnity? And so, as such, why can't it pay itself out of the fund as it goes along, given that the cost order will be made in its favour at the end anyway? This was something else that was explored in Sherburne, because along with this incredibly punchy clause that they'd inserted into the trust instrument that allowed them to basically pay themselves as they went along, there was another sort of more conventional indemnity clause which was in similar terms, and the bailiff said, well, I mean, no, yes, they may get their costs, but this type of clause doesn't entitle the trustee to prepayment of costs. And if it did, it would potentially be contrary to public policy, as Penny's outlined, because you still can't determine A, whether the costs are properly incurred, and B, whether they've been incurred qua trustee on behalf of the trust, because of course the indemnity clause only protects a trustee acting as trustee, and when you're looking at hostile proceedings, often the trustee won't be acting qua trustee, at least not until you've determined the costs at the end, as they've been successful. But there's also another Guernsey judgment, one of the many judgments in the Cengiz litigation, which said that indemnities don't give trustees carte blanche to incur costs as unreasonably as they want, and that would always be subject to the overriding jurisdiction of the court to control that. Would you agree with that, Penny?
Yes, very much so. And I think it is a mistake for trustees to assume that just because they have these tremendously wide indemnities, they are always going to get their costs out of the fund come what may. It is very much subject to the implication that those costs are reasonably and properly incurred. And we've set out on the slide the passage in Lewin to that effect. And also that there is the FA and FB case, which helpfully named, which actually is very clear on that point. Jo, can we have the next slide? So what are trustees going to do? Can they ask for a prospective costs order or Beddoe relief? And what's the difference between the two, Rose? What are we looking at here?
Well, as you said earlier, Penny, this sounds a bit Blue Peter-ish. As you said earlier, Beddoe relief does not affect the main cost order in the proceedings. It's relevant to the trustee's indemnity, and typically it's used in third-party proceedings where there's a claim by a third party against the trust, and the trustee says, well, I want to know that I'm going to have the assurance of my indemnity in defending these proceedings or pursuing them. Whereas a prospective cost order, it determines the cost order in the main proceedings. So it will mean that there will effectively be no role for a decision on costs at the end of the trial, because it will already have been made. So do either of those, Penny, appeal to you, where a trustee is defending a removal application?
Yes, no, I mean, neither of those possibilities really works. Beddoe relief is simply not available because the trustee is not defending third-party proceedings. It's as simple as that, I think. And as far as prospective cost orders concerned, the rule has always been, as that set out in MacDonald and Horn, that you have to be clear that the costs order at the end of the day will be that the costs will be awarded out of the fund. And I think those principles were set out, Rose, were they not, in the Stander and Schultz South African case?
Yes, they were indeed. And you may think we're slightly scraping the barrel with this one, but actually Stander and Schultz is footnoted in Lewin, so it's got those creds. And it was a case that is very on point, this case, because it's a case where beneficiaries sought removal of the trustees, and the trustees made an application saying, well, can we have our costs out of the fund, please? There are a number of serious allegations made against the trustees, although, as we said, we don't think it really depends on whether there are serious allegations made or not. And the court did quite a detailed exploration of domestic legal principles, as well as looking at Commonwealth authority, including Skafteros and Dimos of previous slide fame. And interestingly, the judge said that the counsel in the case, his research assistant, they'd all been looking, but they'd been unable to find any English case in which a trustee faced with an application for removal had sought a preemptive cost order. And obviously, our view is that there are good reasons for that, i.e. that they shouldn't get one. The trustees were very much told to take a running jump in Stander. The court said that the application was fundamentally misconceived, because what the trustees were asking the court to do was to rule that regardless of whether or not they were acting reasonably in opposing the application, they should have their indemnity. And he said this is contrary to all authority, as well as basic notions of justice and common sense, which is pretty much as, I think, decisive as you can get. Jo, can we have the next slide, please? Penny, I mean, there is some suggestion in the authorities that you might be able to get a prospective cost order in category 2 proceedings in exceptional circumstances. Do you think that this really works in the context of a removal claim?
No, I think it's very difficult to see circumstances in which that would apply. There is an analogy here, perhaps, with cases where there is an order restraining somebody from disposing of trust property, a proprietary injunction, effectively, where it has been held that whereas when you've got a Morava or a freezing order injunction, you can have your legal costs out of the fund. When there's a proprietary injunction, in general, the principle is that you can't, because you shouldn't be using the property which is in dispute to fund your legal defence. But there are exceptional circumstances where, particularly when it will be impossible for the claim to be defended, where the court has allowed costs to be taken out of the disputed fund. But it's difficult in a removal claim to see where that might be allowed. There's certainly, as far as I'm aware, there's no example of a case where that has been permitted. But I think, Rose, that there are very rare cases, aren't there, where prospective costs orders or a species of Beddoe relief has been granted. Can you tell us about Valmont?
Yes, this was a nice Gibraltar Court of Appeal authority. As you say, I think it really underlines the principles that we've been discussing, which is that it's ordinarily not available. And you can see that from the very unique circumstances of the case, which was, this was an appeal from a Beddoe application made by a corporate trustee of some offshore trusts, Gibraltar trusts. And it was one of those disputed fund claims. It was a contest between the creditors of the settlor who had gone bankrupt. And they said that the trusts were a fraud on the creditors. And the beneficiaries, who understandably said that the settlement was totally okay and fine and totally valid. The beneficiaries were willing for the creditors' claim to be defended at the expense of the fund, but wouldn't offer an indemnity. And the creditors were quite annoyed about this. None of that's particularly unusual, but what was quite unusual is that the creditors had made a direct personal claim against the trustee on the basis that it was party to the fraud. So, I mean, that brings us directly into sort of personal claims against the trustee. And the judge at first instance said that the trustee could defend the claim and down to disclosure. or discovery in Gibraltar, and also applied to strike out the claim, and directed that the trustee was authorised to take its costs of both of those steps out of the fund. And the Court of Appeal refused the appeal and respected the cost of the striking out application, but were more concerned about the judge's order in relation to disclosure. And in the end, what they did was accept an undertaking from the Trustees' Council that a further application effectively for Beddoe relief would be made, straight after the striking out. And the reason why the Court of Appeal considered that the judge's order in relation to the strikeout couldn't be disturbed is because he said that, well, the case against the trustee was very weak, both in respect of the fund and personally. So it might actually benefit the trust estate to abbreviate the proceedings by having the claim against the trustee and the trust struck out. And you can see that those are really unusual circumstances where you've got this sort of weird species of Beddoe relief in respect of a personal claim against a trustee that they've been party to a fraud. And what I think you can draw from this judgment is that although it is authority for the proposition that there may be exceptional circumstances in which a trustee should be able to defend personal claims at the cost of the fund, it really just affirms the general principles that we've been discussing, i.e. that this shouldn't ordinarily happen. And the judgment spends quite a lot of time just saying, well, yeah, I mean, this seems pretty weird and unusual. And you can see why lots of judges at first instance wouldn't have made the order that the judge did. So yeah, Joe, could we have the next slide, please? So Penny, what about this case, which you're going to read out?
Yes, the title to this case, the Macedonian Orthodox Community Church St. Pekka Incorporated, and His Eminence Peter the Diocesan Bishop of the Macedonian Orthodox Diocese of Australia and New Zealand, trips off the tongue. But it is a really unusual case because it does appear to be some authority for the proposition that a trustee faced with removal proceedings and breach of trust proceedings can in fact get some form of Beddoe relief. But there are some points of difference between this Australian case and the English position. First of all, the Beddoe relief in Australia is actually dealt with by way of statute, and so that was important. But essentially, although this was framed as a breach of trust claim, it was really a point of construction of a charitable trust deed. So that was what really was going to solve the problem. The breach of trust claim had no validity if the charitable trust was construed in a particular way. And the court felt that it was very much in the interests of the charity for the matter to be litigated and for the court to deal with it. Hence why it effectively allowed costs to be taken out of the fund by the charitable trustee. And so I'm not sure that a great deal can be drawn from it, particularly because the circumstances were unusual. Also, one has to be quite cautious about the case because it was one of those cases where the Court of Appeal actually said, we can't possibly interfere with the discretion that's been exercised by the judge at first instance. So from that point of view, I'm not sure that it really assists. It is sometimes trotted out insofar as a case with that sort of name can be trotted out in litigation as being authority for the proposition that you can get Beddoe relief in hostile litigation. Joe, can we have the next slide, please? So what do we do about trustees with no assets? And you might think that this is not something that crops up very often, but it does in the offshore world in particular, because of the increased use of private trust companies which are often formed with absolutely no assets at all, unlike the old trust corporations under the Trustee Act, which had to have a minimum amount of assets. And it may well be that those private trust companies also don't have insurance in place, at least for the trust company, even if the directors of the trust company have their own personal insurance, or they may have very limited insurance. So what do we do in such circumstances if the trustee is faced with a removal application? And Rose, you know, what is there an exception for such trust companies?
No, no. Yes, because you might get a trust company that says, well, this is really unfair because we have no assets. We can't pay our lawyers if we're not allowed to draw our costs from the fund. And we think that there are things that the court needs to hear from us, which we can only do by instructing our expensive lawyers. So there should be an exception for us. That's an exceptional circumstance, and one which should justify some kind of preemptive / Beddoe / made up relief that we haven't been able to identify in any of the authorities. And I think the answer to that would be, well, tough, because you shouldn't be able to disadvantage beneficiaries by taking costs out of the fund when you're saying, well, I don't have any assets, so ultimately if I lose my indemnity, I'm not going to be able to pay the fund back ever unless the beneficiaries manage to get some kind of third-party cost order against the directors. So Joe, if we could have the next slide. So I suppose then, if you're saying, well, frankly, tough, you can't have a special exception that gives you a bit of a bung to pay your cost of the proceedings. What do trustees do, Penny?
Well, quite often you find in removal proceedings that get anywhere, you have different groups of beneficiaries, some of whom want the trustees to stay and some of whom want the trustees to go. In circumstances where all the beneficiaries want the trustees to go, the trustees often take the hint and step down because, although not always, I think it's right to say, and there have been, there's certainly been a case recently where there was really only one beneficiary of the trust who desperately wanted the trustees to step down, but that was not considered enough for the trustee to go. But seeking an indemnity from the trustees who, from the beneficiaries who want the trustee to stay is a fairly sensible thing to try to do. I mean, quite often in warring families, that will be the way in which the trustee can make sure they can pay their costs going along and make sure that they're not exposed if they lose the case at the end of the day. So that would be my first point, is really seeking an indemnity from friendly beneficiaries. But Rose, what other ideas might there be?
Well, the second option of the two which we think are sensible options is to, at a pretty early stage, offer to step down without making any acknowledgement of any allegations of misconduct and so on. So you basically say, well, I don't agree with any of what you've said. I think it's all wrong, but I will offer to go. And that is certainly the approach that Lewin endorses at the little citation on the page. But Penny, what are the complications where you have a trustee who offers to go, but then there's some issue over who the replacement fiduciary should be? I mean, that's what happened in Perry and Neupert, isn't it?
Yes, it is. And that's a difficulty because actually it's a breach of trust for a trustee to step down in favour of an inappropriate trustee. And so it is often in the interests of the trustee, well, it's always in the interests of the trustee to make sure that the successor is appropriate. And in those circumstances, and also bearing in mind that the power to appoint new trustees, which usually vests in the trustees, is a fiduciary duty, a fiduciary power, then in those circumstances, the trustee may very well feel uncomfortable about retiring in favour, for example, of a member of the family that they don't think is going to do a good job. So in those circumstances, it can be problematic, as indeed it proved to be for Dr. Neupert in the Perry and Neupert case. So although in general terms, the advice given in Lewin is very good advice, trustees still have to be really quite careful. And it does occur to me that one thing that perhaps could have been done in Perry and Neupert, before my involvement, I have to say, is that maybe Dr. Neupert could have effectively said, I don't want to take any role apart from a neutral one from here on in. There'll need to be somebody else joined to engage with the issue of who is the new trustee. But if I am going to be involved in any way, I want my costs out of the funds. So at that point, make an application for a prospective costs order. And it does seem to me that that might be a way around this particular conundrum. Jo, can we have the next slide, please? So we do have a question from David Catchpole. What about the costs for trustee who agrees to be removed but denies any wrongdoing? Well, I suspect that we've probably covered that in some detail, and really the last slide perhaps deals with that the trustee should agree to be removed. Hopefully there can be an agreement as to who takes over. But if not, it may well be that the trustee in those circumstances should say, I'm going to take a neutral role and let the beneficiaries argue about who takes over. My only concern being that it should be somebody appropriate. But Rose, do you have any further thoughts on that?
No, I think that's absolutely right. And I think it's a good question, because I think as we've seen from Perry and Neupert, it doesn't end with the offer to step down. I think the trustee needs to be hyper aware of that and make sure that it doesn't confuse ensuring that an appropriate fiduciary replaces it with perhaps taking a non-neutral and perhaps non-indemnity safe role in bossing who should take over. We've got another question which I think is relevant, which is, if the trustees agree to step down at an early stage, do the costs still follow the event? Well, I think possibly it depends, I suppose, whether if this has come within the context of proceedings. Well, Griffin and Higgs is an interesting example, although it's slightly different, because there was a split cost order made in that case, because I think the trustees had behaved non-neutrally to begin with and then became neutral, and there were different cost orders made in respect of their different roles in the proceedings. So I think that the court can and often does take quite a nuanced approach in relation to that. But there's another case that we've also discussed, which is Price and Saundry, where the removal application didn't really end up being determined. And the court sort of said, well, we can't really make any determination of whether there should be an inter partes cost order in that regard. So I think possibly the answer is the slightly unsatisfactory one of, well, it will depend. But I think what I would say is perhaps, well, there's likely, the court's likely to say, well, if you've acted unreasonably up until a certain date, then no, you can't have your costs, and then you can have your costs for the rest. That's a slightly messy way of answering that. Do you agree, Penny?
Yes, I do agree with that, and I think it would be very good to say that going at an early stage is going to fully protect the trustee. But I think that the Perry and Neupert case, I think it was wrongly decided, I have to say, but maybe I would say that. I have to say that does demonstrate some danger. I suppose the difference there was that the trustee was implacably opposed to either the mother or the daughter becoming the trustee, and so did in that sense take a non-neutral stance. But it always struck me he had rather good reasons for doing so, because a big and indeed the trial judge ultimately found they shouldn't be administering the estate on their own. They needed to have somebody to check on them. But I think in the general course of things, stepping down at an early stage is good advice to give the trustee. And we've got a really good question. Does the same or a similar analysis apply to the costs of trustees applying to remove a co-trustee? I think that, I mean, for my part, the trustees who are applying to remove their co-trustee, in general terms, will be able to fund that out of the trust fund, because they are, I mean, they presumably, if they're doing that, will be doing it for the benefit of the trust. But that is very dependent on the fact that they are doing it for the benefit of the trust, and of course that those costs are reasonably and properly incurred. And you can have circumstances, it seems to me, where, but particularly a bit like the Schumacher and Clark case, where the trustees were absolute loggerheads, where the court is actually going to say, no, the beneficiaries shouldn't really be paying for this. You know, they shouldn't be paying. So I think I think that, whereas I think that trustees trying to get rid of a co-trustee have got more of a chance, perhaps, of getting a prospective costs order if they can show that they really are taking this action for the benefit of the trust. It's by no means a dead cert that they are going to get their costs out of the trust fund at the end of the day. And what do you think, Rose?
Yeah, I completely agree, and I think there might often be an issue, particularly with often, I suppose, in estate scenarios with executors, where executors are well, family members are both executors and or trustees and beneficiaries, because I think there could be a real risk of a trustee applying to remove a co-trustee, perhaps they're brothers and they hate each other, and saying, well, you know, I'm acting for the benefit of the fund, and actually you might not be. You know, you might be motivated by personal animus, and that is not a trustee-like way to behave at all. I think that there could possibly be a risk of that, particularly in a family trust.
Yes. Yes. So I think, again, it does depend on the facts, and it does depend on whether or not the trustees are acting reasonably and acting properly in those circumstances. So the analysis is not dissimilar. Well, thank you very much for attending and for listening to us. Thank you very much for the really good questions that we've had today. If anything occurs to anybody, you know where we are. We're very happy to deal with any questions that occur to you later. And with that, we both wish you all a very happy summer.
Happy holidays.